One of the most crucial and important aspect of cross-examination is cross-examination of a medical expert. In any case relating to homicide, poisoning, strangulation, causing injury, sexual assault, or age determination, in all such type of cases, the prosecution is required to examine the medical expert, that is the doctor, who has examined the injured, the victim, or conducted postmortem, or determined the age of either the juvenile or the victim. In all such cases, it becomes the duty of an advocate for the accused to cross-examine the medical expert. Now let us put things straight. One, the evidence of a medical expert is not on any higher pedestal than the evidence of a common man. It's on the same pedestal. It has to satisfy the same test of reliability, and unless the evidence of a medical expert is reliable evidence and in consonance with the expected medical standards, only then the evidence of a medical expert can be accepted by the court. However, we find that, which is a practical experience, that like advocates, judges also lack the basic or they do not possess adequate knowledge of medical science or forensic science, and that results in grave prejudice to the accused person, because the judge tries to play safe and rely upon the evidence of the medical expert and discount the cross-examination. Second most important thing is that in the opinion given by a medical expert is an opinion, and opinion evidence is is admissible under section 45 of the Evidence Act. I am not conversant with the new BN section, but the equivalent section is the same, section 45 of the Evidence Act, where it makes it that opinion in respect of foreign law, foreign art, science, the opinion given by an expert becomes an admissible piece of evidence. But it is only, as I said, it's only an opinion piece of evidence. Therefore, it has to pass the test of reliability. Now, to cross-examine the expert, in a medical expert, particularly a medical expert, few things should be taken into consideration. That should be the most important, which any cross-examiner should keep in mind. One, that the cross-examiner should understand what is his case and what he proposes to get from the medical expert. So, the cross-examination is to impeach the credibility of a witness. But unlike any other evidence, the evidence there's no point in confronting the medical expert with your knowledge of medical science. Please try to understand that he is a person who has studied medicine, studied that particular aspect of science. He has studied forensic science, and therefore he can beat you at any time So that is the first principle of cross-examination of any expert. Don't allow yourself to drag that witness to his court where he is comfortable and there he is going to beat you hands down. So therefore, don't try to challenge the witness. What you must do is probe his competence, ask questions regarding his experience, his field of work, and how many cases he has conducted or how many matters he has a witness persons he has examined in that particular science or particular subject on which he is come to give evidence. So first thing you do, you examine him and try to bring on record that the witness is not a competent to depose regarding a particular subject on which he has given opinion, or that he does not have sufficient experience or knowledge to give his opinion on that subject. Make it unreliable. Pose such questions to the witness that raises doubt regarding his competency. Don't, as I said, don't challenge him on the subject itself. Challenge him regarding his competency, which is different than challenging him on the subject matter. Like, please try to understand that any expert witness is always a dogmatic witness. He will never say that his opinion is wrong or erroneous. No expert will ever admit that I have given an erroneous opinion. So, therefore, if you start challenging him upon his opinion, he will stick to that opinion and give 100 reasons to defend that opinion. Secondly, now after having challenged his competence, now you will have to make it that his evidence is not reliable. Now, to make his evidence unreliable or not reliable, you have to rely upon standard medical textbooks and textbooks on forensic science. There are many books, but there are two particular books which I said, Modi and Dr. Ramamurthy. These are the two books which are really good and give a good insight. There is, of course, Lawrence is there, Taylor is there. There are so many other books, but these two books which are readily available, these are the books which because these are local experts, these are experts who have practiced in India, and they are familiar with the Indian circumstances and the practice which are prevalent across the country, and therefore they have given very valuable tips regarding the medical evidence, and you must read those. So now when you start cross-examining a witness, what you normally do is try to bring inconsistency in the ocular evidence vis-a-vis the medical evidence. Now, inconsistency by itself, the Supreme Court says in number of cases, beginning from Solanki's case till date, that inconsistency by itself will not discredit the ocular account unless the medical evidence is such which totally makes it impossible to believe the ocular or the eyewitness account. Now, this is the standard. Still, a cross-examiner has to show that there is inconsistency between the evidence of an eyewitness vis-a-vis the medical evidence. So, the cross-examination should be to that extent, to show that the number of injuries which are not possible by a particular weapon, the injuries are not possible by the manner in which the eyewitness has deposed, the injuries could not have been possible through those weapons which are alleged to have been, these size of the injuries are different. So these are something which you try to discredit the witness by showing the inconsistency between the eyewitness account and the medical evidence. So you have to, when you cross-examine, you say that, all right, you did not, if the witness has deposed that there is an injury on the back and you do not find any injury on the back, you can confront the witness. You can ask the witness that you did not see any injury on the back, or that injury on the back was not possible if the accused and the witness and the victim were standing in front and the stab was given from the front side, or where the assault was from the front side. So all those things you can, to discredit the eyewitness, you can cross-examine the medical evidence. Now this is eliciting. You are not discrediting the medical evidence. You are trying to elicit evidence from it to discredit the eyewitness. Now to that extent, now if you find, I'll tell you, if you find that the medical evidence which is on record discredits the eyewitness, then don't discredit the doctor. So don't challenge his competence. In fact, you have to show that he is a competent witness and his evidence is required to be accepted over and above the eyewitness. In such eventuality, don't challenge the credibility of the doctor and say that, all right, now doctor, you have seen the injuries, you agree with this thing, and he will readily agree if on the basis of the medical evidence. Third thing, you have to cross-examine regarding the observation pattern. See, the observation, because as I said, when you challenge a report, you challenge the report on the reliability, the accuracy, and the question is the accuracy, and on the basis of the accuracy, you and the probability, you can make his opinion questionable. So you have to see that whether the doctor has, or a medical expert has examined and seen all the injuries, whether he has missed any injury. Because normally what will happen, I'll tell you, that's a practical experience. Anybody who are practicing in the criminal side would know that when the injured is taken to a hospital, the doctor at that point of time does not note all the injuries. And many a times you will find that the injuries which are noticed at the time of postmortem are not mentioned in the OPD or IPD papers. Some of the injuries are different, which are found in the postmortem report and which are not seen in the IPD and the OPD papers. So this is a very common thing which we have come across. Now therefore the question is of the accuracy of the observation, because the reliability of the evidence of a doctor will also depend upon the accuracy of his observation. So you have to challenge with regard to the accuracy. Now when you challenge regarding the accuracy, many a times, and I have seen many of times what the cross-examine him with regard to the time of death, the probable cause of death, the manner in which the wounds were inflicted. But at that same time, when you are cross-examining a witness to find out the time of death, or that is to discredit any eyewitness, particularly in a case of circumstantial evidence, the time of death plays important. It is very important in a case of circumstantial evidence rather than in a case of a direct evidence. But in a circumstantial evidence, the time of death, and the time of death in India, unfortunately, is dependent on the rigor mortis only. Now, rigor mortis, PM lividity, on that basis, it is given. Now, this rigor mortis, as everybody knows, depends upon the climatic conditions. It is all and no doctor on earth can give an exact time or the exact time of death. It's always in a probability. So there, when you cross-examine a doctor, keep in mind what is your case, what is the time which you want the alleged incident to happen, and therefore accordingly cross-examine that doctor with regard to that probability. Because there are many probabilities which we suggest to the medical evidence, that these injuries are possible by fall, these injuries are possible by any blunt object, these injuries are possible in a mutual fight. There are so many suggestions that we put. Same case, well, cross-examining a doctor with regard to the probable the timing of death, because it's all probable kind. So you can always suggest a possible time of death. And when you cross-examine a doctor with regard to his opinion, now this will be determined by only with regard to the rigor mortis. There is no other means in which they employ, because what has happened in India, they don't take the temperature. Because in abroad, if you find, whenever an autopsy is done, whenever the dead body is brought, first thing they do is to take the temperature of the body. And from the temperature of the body, they calculate as to what could be the time when the person died, and not on the basis of rigor mortis, which is done in our country. Then there's another aspect which is more important, which comes to with regarding the age determination also, or the age determination. Now, age determination based upon, which is with regard to the eruption of the molar teeth, or on the basis of your the bone joints in the bone. That is the only way that the age is determined. And there again, there is a variable gap of plus or minus 6 months as far as the eruption of the molar teeth is concerned, or the joining of the bones, there is plus or minus 1 year, or depending upon different textbooks. We have different textbook. Modi has gone to the extent of plus or minus 2. So wherever these conditions are there, these are the books come handy. And I tell you, these are some of the books which no medical expert would discount, and no medical expert would say that Modi's textbook is not, or is now even Ramamurthy's book, that is not standard medical textbook. Because these are the books which are prescribed even in the subject of forensic in a medical college. And every high court, every Supreme Court, and all matters, they have consulted Modi, and have to arrive at any opinion, have relied upon Modi's medical textbook. So keep that book in handy. On the basis of that book, try to understand your case. Now, the difficult cases which I said are with regard to where there is a circumstantial evidence, or where there is the case of poisoning or strangulation. Now, these are very difficult cases where the cross-examination, you have to cross-examination to impeach the opinion of the doctor, because in a case of strangulation, the most and more probable defense that is taken is of suicide. That is, the person had committed suicide and not committed, and there is no manual strangulation, or there is no, it's not a case of homicide, but it's a case of suicide. Now, in these cases, both whether there is a strangulation or whether there is a suicide, these signs, the classical signs which are seen, these are, most of them are common. There are few signs on the basis of which it is determined by the doctor on the basis of. Now, what happens is, the advantages to the cross-examiner is that in 90%, now of course due to the new BNS Act, the doctors are supposed to visit the scene of offense, and also go through the panchanamas. But prior to that, no doctor had ever visited the scene of offense and is not aware. So therefore, the opinion that this is a strangulation and not a suicide is very, very tentative. Very, very tentative. If you go in deep, if you go in depth, as far as the science of the medical, because ultimately it depends upon, any opinion of a doctor is only as I said, an opinion evidence, only a piece of a corroborative piece of evidence. Ultimate evidence is the direct evidence of a witness. So if the direct evidence is there, on the basis of which you can suggest that this was not strangulation, this was not a manual strangulation or not a homicide, but it's suicide, you can definitely get the opinion from the doctor. But you have to be careful as far as putting an opinion before, because doctor, if you suggest an alternative possibility, if you suggest that, yeah, all right, doctor, you may be right, but this is also equally possible, and I tell you 99% of the time the doctor would agree with you if you tell. But you have to keep in mind that you must respect his opinion, because as I said, they are very dogmatic. No doctor or any expert would say that I arrived at an erroneous opinion. So all right, you suggest him an alternative, that doctor, all right, this, but in view of this, whether this is equally a great possibility, and he would definitely agree that there is a possibility. Now, while examining a medical expert, as I said, the reliability, the accuracy, and the opinion which is given by him, the question is, you have to raise only questions that this opinion may or may not be correct. That is all that you are required to while cross-examining a doctor. So there is no question of destroying the evidence of a doctor. All that you have to raise suspicion in the mind of the court that their opinion may not be correct, particularly in light of the suggestions which you have put, which is equally, and the doctor has partially or fully agreed to this, that these possibilities are there. Now, there are so many people waiting, so I'll not, I think I've taken more time. This is a subject which you can go on for hours together. And of course, I wanted to tell you about the ballistics also, as far as why the ballistic and the forensic, but then some other time, after, whenever your president will call us. But my colleague at the Bar Council, Mr. Konde Deshmukh, is very eager to speak. And there's another candidate who has come. I don't know her name, but Anu? Vanmala Anuse. Well, good luck to you, madam. Welcome. And you are eager to hear. Only I'll tell you one thing, which your colleagues had requested me. As far as the Bar Council elections are concerned, please remember, this is a vote by a single transferable vote. So this is single transferable vote. So you have to give preferences, only one preference once only. You don't have to repeat the number at any point of time. You may give 5 numbers, you may give 4 numbers. And Mrs. Castellano is also here. She is our colleague from the High Court. आता हे जे आपण जे इलेक्शनला आपण जे वोट देणार आहे ते आपल्या मराठीत सांगतो, आपल्याला जे पसंती आपल्याला द्यायची असेल ते एक नंबर दिला तर एकच द्यायचा आहे, 2 3 4 5. महिलांचे समोर डब्ल्यू लिहिला असेल टू आयडेंटिफाय दॅट दे आर लेडीज, बट यू हॅव टू वोट अकॉर्डिंगली टू द प्रेफरन्स. दोन एक देऊ नका, 2 नंबर देऊ नका, 3 नंबर एकच वेळी द्या, सगळे नंबर एकच वेळी द्यायचे. आणि एक हे नंबर देताना जास्त 23 पर्यंत जाऊ नका, काय होतं भूल होते त्याच्यात. आणि अनेक वेळा आपला बॅलेट इनव्हॅलिड होतो, कारण आपण लिहिताना आपण 1 2 3 4 लिहिल्यानंतर 4 स्किप केला, 5 6 7 केला, 8 स्किप केला, हे विसरून जातात. काही होतो असा, बिकॉज एवढं हे पेपर बुक पण एवढी मोठी जाड असते, ते बघावा लागतो आपला कॅन्डिडेट कुठे, आणि हे शोधायला टाइम वेळ लागतो. म्हणून ते करताना हे लक्षात ठेवा की आपण जे नंबर देतोय ते कन्सिक्युटिव्ह ऑर्डर मध्ये देता. एकही नंबर स्किप करू नका देताना, 1 2 3 4 नंबर स्किप करू नका, 5 4 5 7 असे जेवढे आपल्याला प्रिफरन्स द्यायचे द्या. त्याच्यात कुठलाही मिनिमम क्रायटेरिया नाहीये, मी तुम्हाला स्पष्ट सांगतो. पण 2016 चे कायद्याप्रमाणे 5 देणं त्याचा कायदा होता की मिनिमम 5 द्यायचे. म्हणून आपला बॅलेट पेपर व्हॅलिड होण्यासाठी कमीत कमी 5 तरी द्या. आपण 23 पर्यंत देऊ शकता, आता 25 नाहीये, 23च आहे, तर 23 पर्यंत आपली पसंतीचे वोट देऊ शकतात. आणि वोट आपण जसे केलं ते आपण लेटर मध्ये पण लिहू शकतात, पण इंग्रजीत लिहायचे आहे साहेब, हे मी आपल्याला स्पष्ट सांगतो. आपल्याला मराठीत नाही लिहायचं आहे, इंग्रजीत लिहायचं आहे. आपण 1 लिहा, ते इंग्लिश रोमन इंग्लिशमध्येच लिहा 1 2 3, किंवा रोमन मध्ये लिहा 1 2 3, जे आपले पसंतीचं. धन्यवाद साहेब, मला इथे बोलवला आणि बोलण्याची संधी दिली आणि सगळ्यांची भेट झाली. धन्यवाद. जय हिंद, जय महाराष्ट्र.
Thank you, sir.